It is January the 14th, 2026, and this is the Court Gallery. Let me get situated. Ladies and gentlemen, we've got to have a heart-to-heart. Tonight we have a night full of crazy court. This is the second day in a row that Judge McNally has had a day where he looks like that right there. I mean, today we've got the guy who's been arguing with the city about cleaning his property up for 25 years. He's back. And then there's another little something that I threw in there that I thought was interesting. Aside from that, we have a big chunk of Judge Mogan, and she's spreading the mom vibes out wide on this one. There's some very special cases in the Judge Mogan block, but of course, the case of the day, the case that everybody needs to see, if you haven't seen it already, is the Judge Hayward AI lawyer debacle where she decides on what the sanctions should be for the lawyer who decided he was going to use ChatGPT for his motions and pleadings and all that type of good stuff. And it was very interesting also. And ladies and gentlemen, all of that starts right now.
Okay, I'm going to ask you to stay here. People against Robert Thomas Boyd, 25BA2557. How you doing, Mr. Boyd? Come up to the podium. Ms. Foley Carter, your name?
Caitlin Foley Carter, from Nebraska Township.
Mr. Boyd?
Robert Thomas Boyd.
So you're here for a review hearing, and you have the right to an attorney. If you would like an attorney, I'm going to give you one now.
No, thank you.
You waive your right to a lawyer?
Yes, sir.
Please tell me that there's been substantial progress on the property. I'm talking to the prosecutor.
Okay.
I would define it as substantial, Your Honor. I did have the department, somebody took photos from the street on Thursday. It shows the boat, the amount of the vehicle, the trailers. He got a large delivery of wood that is now in front of the property. There's junk along the side. I do have those photos if you want to take a look at it. I do see that the trailer in the back of the property is full. Mr. Boyd did say that it was full. It just needs to be cycled out and he needs to keep working on it. He also has not obtained a demolition permit yet for that dangerous building back in the back.
I don't know what to do with you.
I don't know how long it's good for, so I'm waiting and, I can't get the trailer out because the guy went up deer hunting and then he's up north with his boss working on.
Whose trailer is that?
Happened.
Whose trailer is
So he's coming back.
that? Whose trailer is that?
The dumpster.
Yeah.
Wait a minute. So it's being used as a dumpster, the trailer is?
The trailer is a dumpster.
Okay.
There's a large red dumpster. You can see in some of the photos.
Yes.
That is full. There's still all the trailers being used as storage essentially though on the property.
What are you doing with the boat?
Trying to sell got a for sale sign on, got it out by the road.
How long you had that up for sale?
Well, it's the middle of winter, and
No, I didn't ask you that. I just want to know, can I have
Oh.
another page, second page to a register of actions?
since,
I think it's been about September or October, Your Honor.
All right, talk to me, not to her.
No,
I'm
it's
just-
in November when we put it out there.
I mean, it does look a little better. I'll give you that. But you still got to get the boat out and you got to get the garage torn down.
I've had the flu since Christmas.
What's in the trailer?
I believe that Mr. Boyd has taken property out of the garage and that's what's in the dumpster.
Well, no, but there's a trailer. Is this not a trailer? This black, it looks like a black trailer to me.
Yeah, there's about 2 or 3 trailers on the property. They're just full of, excuse my language, junk. So those need to go. You can't use storage like that on the property.
When are you gonna get rid of the junk in the trailer?
A lot of it isn't junk.
What's in the trailer?
Tools. I gotta put my, rototiller in there, my lawnmower in there.
Tools,
Yeah.
lawnmower?
Yeah.
What else? Is it filled up?
No,
What else do you have in the trailer?
no, I got some kitchen cabinets that I gotta put up
You're gonna put them where?
Huh?
Where are you gonna put them?
in the kitchen.
How long have you had the cabinets in the trailer?
November, December,
Where'd you get the cabinets?
my daughter. She,
What?
remodeled her kitchen. And, they're all handmade cabinets. They were too dark. She wants white.
Who's gonna take the dumpster out of there and take it to the dump?
The man who owns it. I rented it. $400 a shot.
Is it filled up yet?
Yeah, it's good.
When's he coming? When's he gonna come get that?
I'm gonna call him today, see if he's back in town.
What about the other inoperable vehicles?
The inoperable vehicle, got a broken shock, I gotta put it into the.
These are the same vehicles been sitting out there.
They are, Your Honor. See with the trailers, those have all been there since we did this.
I don't know what you're gonna make me do, Mr. Boyd.
Well,
Mr. Boyd, come on.
I gotta work on the garage, getting it in. Everything else is secondary.
Well, that's your opinion. That's not my opinion.
We do one thing like that at a time.
Mr. Boyd.
Top.
Mr. Boyd, I'm gonna let the prosecutor remind you how long they've been dealing with this, with your property.
Your Honor, I believe these citations date back to 2001.
So it's only been 25 years,
I didn't know about it.
Mr. Boyd. I don't know why you're not good. I don't know why you're just insisting that I send you to jail. I don't understand it.
I can't do anything, you know.
Mr. Boyd, you're not doing anything out of jail either.
Can't do anything. till-
Mr. Boyd, this has been 25 years. 25 years, sir. I was young. I'd like to go back 25 years. This is my early 40s, 25 years ago.
Nobody come and talk to me. Except for, the guy that retired,
What year did he come and talk to you?
just before Rob took over.
What year was that?
Last year, 25.
So you're saying you didn't know anything about this until 24? The township hasn't been bothering you to get this junkyard picked up, sir?
Well, he just come and.
Sir, I'm asking you when your first notice was from the township that you had a blight condition, they wanted things out of there.
Nobody called it a blight condition.
Sir, when did you hear from this township in reference to the condition of your property?
Probably 24.
So you guys are off by 23 years. She thinks it was 01, you think it was 24. That's one big difference. Now, I hear a lot of opposite stories here. Some people call it one, some people call it a million. I hear different stories, but that's quite a disparity. That's 23 years, not 23 days, not 23
That's
weeks.
when I got the letter in the mail. 24.
Would you look on the computer, please, for me? Can you pull up Mr. Boyd's name, please? I like you. I do,
I like you.
but I have a job.
So do I. I gotta get that.
And you're not following orders of the court.
Nothing I could do with being sick.
Mr. Boyd, you've given me every excuse under the sun.
Oh, it's a bad flu.
Well, let me see here. I see Robert Thomas Boyd. Allow inoperable vehicles, 2002. Improper storage, 2003. There's other ones that were set aside under a statute, building code violation 24. So they were dating back to 02. I don't know why they let it go from 03 to 24, if that's what they did, but you've had since April of 25 to get rid of this stuff. And I don't know what to do with you other than just lock you up. Like,
I think if it was,
Mr. Boyd,
2,000 feet.
Mr. Boyd, I've had every excuse under the sun from you. I don't know how many times you've been in front of me on this case. I have had every excuse under the sun. You're sick, your boys won't help, they're too busy, you don't have the money, you gotta go to work, it's too warm, it's too cold, it's too this, it's too that. And here I am trying not to send you to jail and knowing when I don't send you to jail that I'm not handling my office appropriately. You know that? That's what I'm doing. I'm not handling, I'm just not following what I should do and what I do. So basically, somehow, some way, I've treated you better than I treat anybody else.
I appreciate it.
Well, no, but I don't want to treat you better. I feel sorry for you. I'm trying to help you. I'm trying to reason with you, and you're not taking any reason.
But if
You're just not going to listen to judges. You just don't. I don't know if you think I'm kidding up here.
I'm working on it. I've got 2 trailers full of junk out of there already. 2 dump trailers. They're big.
You got to get the garage done. You got to get the trailers out of there, the dumpsters. You got to get the junk out of the trailer. You got to make sure that your vehicles are operable, not inoperable. Are
Yeah,
they properly plated? No, they're not properly plated either, are they?
yes, they are. And they're insured.
Why did the township wait so long? If they were dealing with this in 02 and 03, what took them 21 years to start?
It wasn't anything like that.
Hang on, and let me talk to her. I was talking to her. I wasn't talking to you. Why did they wait so long?
Greg, I do know that Cruz issued municipal civil infractions that are handled through the township on with multiple notices.
Are you gonna deny that too?
What?
She just told me that multiple municipal civil infractions, which would not have been filed here, were issued to you many times between 03 and 24. Is that true or is that false?
I had.
True or false? Just give me a straight answer, please. I don't want to have to be a dentist today. I just don't. Is that true or false?
Well, it's not that simple.
Did they send you municipal civil infractions or not? It is simple. What's hard about that? It's either yes or it's no.
In 2003, I had 2 cars in my yard.
Mr. Boyd, I'm just asking you a simple question. Between 2003 and 2024, did this township send you municipal civil infraction violations or did they not? In other words, is she lying to me? Is she lying to me?
I wouldn't think so,
Okay, so she did, so they did send you notices, right?
but I have.
Right?
Evil.
Right or not? Please tell me if I'm right. I'm gonna get agitated if you keep playing with me. Did they send them to you or not?
I don't know.
You don't know?
My ex-wife picked up the mail.
Oh my gosh. You know what I want to do to that? That's what I want to do to that. That's ridiculous.
She didn't like me too much.
Boyd, you got 2 months to get everything taken care of. I'm going to give you one last chance. This is not a threat. This is a promise. I'm going to adjourn the review hearing. You've got to get, you got to do this. This is not a request. This is not a suggestion. I'm not asking you anymore. I'm telling you, this is what you're going to do. Do we understand one another?
Yes, ma'am.
The last thing I want to do is put you in jail. But I'm going to do it if you don't have the property cleaned up like I told you multiple times. Give me a date in the end of March, Heather.
We could do March 25th, Judge.
March 25th at 8:30 in the morning. You want to take your, did you have something to say?
Just briefly, I did want to remind Mr. Boyd, I know we talked about it a little bit, is that there's a Good Samaritan with a team of people that want to volunteer to help him clean his property. It's my understanding that he says that he doesn't need her yet, that he had one person before, but I think that this is a much larger problem.
They'll help you.
Yes, sir.
If you,
I have to have somewhere to put it. The trailer in my yard, the dump trailer is full. That guy's been away for 6 weeks.
well, tell them to come and get it.
I did.
Listen to me.
He's telling me.
Take the help that the township's offering you. There's going to be no excuses next time. You understand? You do what you got to do, but I'm telling you right now, you've been in front of me on a multitude of occasions on this case, and I'm telling you, if you don't have that property cleaned up to my satisfaction in a compliance with the orders that I issued previously, I'm giving you the other remaining days, whatever they are. Do you understand me?
Yes, sir.
Take your photographs back, please. You can keep these and you can mark down what day they were taken so you can bring them next time and have updated photos. Thank you very much. Go down the hall, get your notice, sir. Good luck. I'm telling you, I'm not going to do this again. Christopher Thomas Hall, 24I-721-000. Oh, come on up. I didn't see you back there. I'm sorry. If you're around here, I wouldn't mind
Excuse me.
doing that search warrant.
Walked outside.
Yeah, I'm used to it. These guys all come to court and they sit in the parking lot. I don't get it, or the hallway. I've never seen anything like it. It's like there's a. So maybe I can do that search warrant for you, okay? Mr. Hall, come on up.
Sorry, I didn't restroom.
No problem. Christopher John Hall, 24I-721-000.
That's not my middle name.
Or Christopher Thomas Hall. You know, when you get old, You start to misread things like that. Okay, I'm sorry. 24I-721-000. Mr. Hackett, your appearance.
Good morning, Your Honor. If it pleases most honorable court, William Hackett, P65962 on behalf of Mr. Christopher Hall.
Your name, sir?
Christopher Thomas Hall.
Detective?
Detective Yes.
All right, so I have here what? OWI 3 and the next count of OWI 3. The first is high BAC. So for purposes of arraignment, does he stand the waive formal reading?
My client will waive the formal reading. My client will stand mute as the court does not guilty plea on my client's behalf.
Sir, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You also have the right to be represented by your lawyer, not only today, but at all subsequent court proceedings. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand them?
Yes, Your Honor.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss the case with the prosecutor. At the preliminary examination, they have to prove that the crimes were committed that you're charged with and that you were the one who probably committed the crimes. If they prove that, you'll be bound over for further proceedings to the circuit court. Do you understand that?
Yes, Your Honor.
All right. Probable cause conference, you're going to be in front of Judge Heston on this. It's going to be January 27th at 9:30, preliminary exam, February the 3rd at 11, okay?
Judge, on the PCC conference, I have 3 matters scheduled that morning.
Where at?
I'm in Macomb County at 9 a.m.
Do they let you do them by Zoom?
Pardon?
Do they let you do
I
the?
can do Zoom, yes.
Well, why don't I make it a little bit later in the morning? And if you can get done with these, we can make it 10:45 if that's okay with you. If you think you can do it.
I'm in Carroll as well in the afternoon, so that would be very good, Judge.
Yeah, 10:45, January 27th, February 3rd at 11. Okay, let me hear your argument for bond here. Where's he been? Why didn't he show up? This warrant was issued.
I included with the advice of rights a letter from Redemption Road Recovery Center for Men in Kentucky. That's where my client has been since January of 2025. He's been in recovery at Redemption Road. I also.
Am I reading this letter from the lawyer, Paul Baker?
Paul Baker he's affiliated with Redemption Road. My client has been working with his construction company while he's doing residential recovery. He's completed program down there, and he made arrangements to come back up here, and
Does he live in Kentucky?
he has been living in Kentucky since January of 2025 when he checked into the Recovery Center for Men.
When did you find out about this warrant, sir?
After I was already there, Your Honor.
I know, but you should have called here and had us Zoom do this.
Because I had contacted the court when I was contacted by my client's father, just prior to him finishing the 6-month program before he went into the recovery. Recovery living. And he just got to the point where he's strong enough to be able to lead and to be here. He's had a year of sobriety now. And he wants to take care of this and move on with his life, Judge. He came up here voluntarily.
But he's still, okay, he's listed on Grange Road. He's not living on Grange. He's living, do you have a father or mother that lives there by chance?
My girlfriend lives there, and that's where I was gonna have the mail sent. I'm in contact with her because I don't have a residence here. I have residence in Kentucky. Then I plan to stay until this is completed and I can go back because I can't, there's no means for me to go back and forth, back and forth.
Wait a minute, you plan to stay in Kentucky?
Permitting. But while the court proceedings are going on, I was going to stay here.
I see. Okay, what else do you want to say?
Judge, he's been working, he's been sober, he's been tested quite frequently.
What does he do for a living?
He was doing construction work down in Kentucky, building houses. And Mr. Baker owns the construction business. Since he's been here, just before Christmas, he's been going to Thrive, which is
Sir, you gotta take your hat off.
Christian Recovery Center.
All right, I've heard enough. I'm gonna give him a personal bond here. Sir, I'm gonna give you a $10,000 personal bond, but there are strings attached to it. You cannot leave the state without consent of the court. You can leave by the way, you don't have an objection to that, do you? You cannot leave the state without consent. I'm gonna let you go to Kentucky without consent. You cannot violate a law. You must appear in court as directed. We'll send your mail, Heather. Make sure you make a note of that to the Grange address, since that's where he's gonna be living during the pendency. Also, you have to go to AANA at least 3 times a week. That's gonna be in person. And also, you have to be on a SoberLink device by the end of the day. Okay? So they're going to explain to you where to do that, where you can get that. You're going to have to go out to Livonia. So you have to be on a SoberLink device by the end of the day. It's a machine you're going to blow into 5 times a day. Okay? And that's it. What did you want to bring up?
Judge, my client has been involved with this Thrive Christian Recovery Group out of South Point Church in Trenton. He really didn't have a whole lot of success with the AA program. This is a recovery program that's Christian based, that's similar to what he's.
Okay, what did you call that again?
Part.
What did you call that again?
It's called Thrive, and it's a part of South Point Church in Trenton. The right case is Tom is associated with it.
I'm just going to say, or any combination of AA/attendance at the Thrive program. Okay? So 3 times a week you have to go though. Okay? Either way. You understand? Is there any problem with that? Do they have it 3 times a week?
No, they do not. They only have it 1 time a week.
Okay, so you're going to have to still go to AA twice a week then, okay? All right? Good luck. Anything else, Mr. Hackett?
No, Judge.
You'll be in front of Judge Hester when you come back. If you want to wait around, I'll take a couple, please, and I'll do the search warrant.
No problem, be in the room. I just want to remind you that he does not have a valid license, so, and his places that he's going to make sure he has a ride.
Yeah, you got to revoke the license. You realize that. You can't drive, right, sir?
Yes, I do understand.
Okay.
He hasn't been driving.
I'm not saying he was. I'm just reminding him. All right? Good luck. Thanks.
Thank you.
Thank you.
And I'll
Please.
get the Zoom information at the county for the
PCC, yes. Because they're going to give you Judge Hessen's.
Thank you very much.
Okay, thanks.
Miss Martin, can you hear me?
Yes, I can.
Excellent, thank you. We will go on the record in the matters 23 CT 74, 24 CM 175, 25 CF 51, State of Wisconsin versus Shannon Martin. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Martin appearing by video conference, well, by telephone conferencing with approval of court. We have Zachary Fisher, her counsel, appearing in person. We're set today in this matter for a plea and sentencing. Is this matter proceeding as such, Mr. Fisher?
It depends on how the court is comfortable proceeding. Ms. Martin contacted me over a week ago saying that she was going to be in a treatment facility. I did try to send her the plea questionnaire. However, I imagine due to her treatment, she was not able to get back to me. I frankly am very glad that she did appear today. We do have a resolution for, if the court was to follow the recommendation, it would be a plea to misdemeanor possession of THC in the 24 CM case. All remaining counts and charges would be dismissed and read in, particularly the theft would be dismissed and read in for the restitution that is being requested by the victim. And there would be a joint recommendation for costs only.
The victim is her daughter, correct? And so
Yes.
Victim is in there where there's victims' rights compliance and in agreement with this deal.
There's victim rights compliance. The victim would prefer jail though.
Okay, but that's the victim's preferences. The state does not have to abide by what they would prefer or like.
I follow McCleary Galleon.
So, correct. So your agreement that you have extended is a misdemeanor THC, dismiss all other things costs?
Yes, largely because she has enough money posted already to cover the restitution.
And I know she does. And so are we in victims' rights compliance as to a plea and sentencing?
Yes, we are.
What about her driver's license?
Your Honor, I don't believe she currently has her license still. I believe she still has some outstanding fines that she would need to pay before her license would be reinstated.
How many fines do you owe in order to be able to get your driver's license back, Miss Martin?
I'm not sure. I have paid, I went to court on that, and I think I'm really not sure. I think it's like four out of six. I gotta pay 4 fines out of 16 or something.
Yeah, I know. I was wondering if she was just thinking or if it was cutting out. Ms. Martin, it doesn't sound like we have the greatest of all connections. So you
I
said
think
that
I have
you had
four out of 16. I think I gotta pay 4 fines.
Okay. Ms. Martin, are you looking at having these matters resolved here today? You can enter a plea and sentencing. The court would be fine with that, but you do have the right to be here in person if you wish.
You mean my fines?
Right. It would be pleading guilty to a misdemeanor THC count. And then the recommendation to the court is fines and fees and restitution.
Yes. Yes, I want to take care of it today.
Okay. All right. Mr. Fisher, I'm comfortable with it. If you're comfortable with it, as Ms. Martin is.
I am comfortable with it, Your Honor. We discussed the agreement at length several times. I just was not able to formally fill out a plea questionnaire. I believe she does understand that. I believe she would be entering a knowingly involuntary intelligent plea today.
Thank you. And I believe that it's $750 in restitution, or is there some other obscure amount?
It's 900.
900. Okay. Why do I have
740 plus 260. She had to pay money to pick up the vehicle.
740 plus 260? Okay. So it's $1,000? Do we have a supplement? Yeah, we do. Okay.
That math isn't right. It should be 1,000. Judge is right. 260 plus 740 is 1,000.
Yeah, the supplement says 900, but it does have those two separate individual numbers. It's just added incorrectly. So we do have, so it's $1,000 that is being requested. Okay. All right. So Ms. Martin, do you understand that you would have the right to be here in person to enter a plea and to be sentenced?
Yes.
And you are asking the court to allow you to appear by telephone conference today to enter a plea and be sentenced?
Yes.
How old are you?
51.
Can you read, write, and do you understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last 24 hours?
No.
Any mental illnesses or disorders?
No.
Do you understand that because you're charged with crimes, you would be entitled to constitutional rights, but by pleading guilty, you're waiving and giving up those rights?
Yes.
You understand that you would have the right to a trial, you would have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights that you would be giving up here today?
Yes.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
You understand the state would have to prove as to count 2 in 24 CM 175 that on or around August 20th, 2024, you possessed a substance, the substance was a controlled substance, THC, and that you knew or believed that substance was a controlled substance, THC. Do you understand what the state would have to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $5,000 and 30 days of incarceration or both. Excuse me, it's $1,000 and incarceration of up to 6 months or both.
Yes.
You understand that there is an agreement reached between both sides in which there's a recommendation to the court for costs only and restitution. Do you understand I'm not bound to follow that?
Yes.
Said differently, I could sentence you all the way up to that maximum penalty if I thought it was warranted. Do you understand that?
Yes.
You still wish to proceed and enter a guilty plea?
Yes.
Admitting here today that you in fact did possess a substance, THC,
Yes.
and you knew it was THC?
Yes.
Did you review the facts that are alleged in that criminal complaint with your attorney, where it basically
Yes.
says what happened that day and why you were charged with the crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Mr. Fisher, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty today, Ms. Martin?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing,
Yes.
and you are doing so voluntarily.
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No.
Are you satisfied with your attorney's services?
Yes.
You believe he's done a good job?
Yes. Yes.
He's discussed these cases with you thoroughly?
Yes.
And Mr. Fisher, you indicated to the court earlier that you believe that she's entering her plea freely, intelligently, and voluntarily.
Yes, Your Honor, I do.
And you went over the facts alleged as well as what the state would have to prove her guilt beyond a reasonable doubt,
Yes, Your Honor.
and the maximum possible penalties.
Yes, Your Honor.
All right. Any questions, Ms. Martin, before I ask for your plea?
No.
As to count 2 in 24 CM 175, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of possession of THC. The other count in that case and the other 2 open matters will be dismissed and read in for purposes of sentencing. Judgment of conviction will be entered today. Argument, Mr. Schmidt.
The reason for this agreement is to really make the victim whole. This is a family member. This is the daughter of the defendant. Defendant is 53 and has no criminal history in Wisconsin. In Minnesota, she has 3 convictions. One is a DC from 2018 involving a family member. Another is a conviction for using the same victim, SS in this case, her daughter's credit card without permission in Minnesota. And then the last one is a 2022 conviction for possessing methamphetamine. So her history, her criminal behavior is largely centered on family or drugs. This is a drug conviction and it's making whole family member. Thank you.
You said she's 53, but I thought she said she's 51. Not that it's a big deal.
Oh, 52 is what our records show if she was born October 29th, 1973.
Is that your birth date, Miss Martin?
Yes.
Okay, thank you.
Oh, yeah.
Yeah. Okay, so she understands. Women kind of lose their
I forget mine too.
their number. So, Mr. Fisher?
Thank you, Your Honor. I do believe this is an appropriate resolution. There were in terms of the felony that is being dismissed and read in, there were a lot of disagreements and factual discrepancies there that I believe is part of the basis for the state's resolution. In addition to the fact that the restitution is being paid, it has already been posted and will be paid very swiftly and fastly to the victim, which I believe is the primary purpose in cases where property crimes are the issue here. I believe Ms. Martin she is ultimately entering into her own treatment program. I believe she understands she has some needs. She told me that without even really asking if it would have any benefit to her case. I believe she did that, frankly, entirely on her own behalf. And so I do believe this is an appropriate resolution given the circumstances here today.
All right, thank you. Ms. Martin, is there anything you would like to add or you would like to let me know?
No.
Okay. All in all, this appears like it's a good resolution. Although the allegations are more serious in the felony matter with taking or allegedly with taking daughter's vehicle. She's paying back the restitution. That's going to cover and make her daughter whole. I'm not sure of their relationship, but hopefully they can either mend it or they can stay away from each other because it's not serving well, at least at this time. So all in all, in looking at protecting the public, and here it's simply her daughter. And so she should, again, not have any contact with her daughter if her daughter doesn't feel that she is comfortable in doing so. But the agreement is appropriate. What I'm going to do is I'm going to order $1,000 for the restitution to be paid over to the victim. And I'm only going to order the $200 DNA surcharge. I'm going to waive the rest of the court costs and fees. She has $1,200 posted. That will take care of the amount that she has posted. And then she won't owe Burnett County and she can just be on her way and hopefully stay out of trouble. Ms. Martin, you have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You may have attorney fees that you owe. I'm not certain. Can't recall if Mr. Fisher, you are court appointed. So you are going to have to pay those. If you fail to pay those the attorney fees, the court will issue a warrant and you could sit up to 6 months in jail. Okay, so it's very important you make sure that you cover those attorney's fees and have them paid off. I do need your DNA. What you're going to need to do is go call the Burnett County Sheriff's Department and see if they need your DNA. If they do, they'll tell you how to go about getting that done so it can get to them. If they don't need it and they already have it, they'll say you're good to go. You may be able to request that it be expunged through the CODIS system through a written letter to the Department of Justice, not to the court, but to the Department of Justice. I think that covers everything, Mr. Schmidt.
Nothing from me.
Mr. Fisher.
Nothing further. Thank you.
All right. Thank you. Thank you, Ms. Martin. Good luck at treatment.
Thank you.
We will go on the record in the matter 24 CF72, State of Wisconsin versus Stacey Shannon. The state appears through Special Prosecutor Aaron Marco by video conferencing with approval of the court. Stacey Shannon appears by video conferencing in custody in Burnett County Jail. And we have Glenn Keene, defense counsel, appearing by video conferencing capability. We're set today in this matter for a motion to modify sentence. We do have a motion filed by Mr. Keene on behalf of Ms. Shannon asking the court to consider a modification of a sentence. Mr. Keene, first I have to ask, Ms. Shannon, you're appearing by video, so is all other individuals. Are you okay with that?
Yes, Your Honor.
Because you would have the right to say, you know what, Judge, I want everybody to be in person, but you're waiving that right and you're okay with everybody appearing by video?
Yes, Your Honor.
Thank you. Mr. Keene, you may begin.
Yes, Your Honor. At the time of sentencing, we had a joint recommendation for a sentence of 2 years of probation on one count, I believe, and 6 months with good time and Huber on the other count. What the condition was that Ms. Shannon had 50 days to report to jail or find treatment. Ms. Shannon, was unable to find treatment on her own, and according to the letter from probation that was document 81, probation, the DOC was also trying to find programming, but they found in their belief that they needed a more substantial type of substance abuse treatment than is usually offered, the dual diagnosis. So asking under the court's authority to modify the sentence because and the reason I ask that is saying it's not for just reconsideration, but because the court can do that if it finds that, you know, unknown circumstances or unforeseen circumstances would, you know, frustrate the purpose of the sentence. And the purpose was some using jail as motivation to get into treatment in one case and probation in the other case as a means of trying to ensure compliance with rehabilitative efforts for an extended period of time. So Miss Shannon, you know, was not able to do that. And what I'm basically asking is that Miss Shannon's remaining time in custody on the 4 months sentence be converted to time that the probation agent can use at his or her discretion. I realize it's a male agent now, but I know the agents change for non-compliance, and that Miss Shannon's probation in the other case, because it will take some time, be extended to 3 years, and then the condition would be that Miss Shannon complies with the treatment recommendations from the Department of Corrections. So it tries to give the probation agency time to you know, get Miss Shannon in the counseling that they felt is necessary, and they've just been able to get the evaluation done around the time of the hearing in December. Thank you, Your Honor.
All right. So what essentially are you arguing is the new factor if this was a 4 months in jail or treatment?
Yeah, I'm not arguing. What I'm arguing is it was not foreseen at the time that Miss Shannon's substance disorder needs were such that she would need a facility that had a longer waiting period and a time limit for a psychological evaluation, because usually it doesn't take, you know, around 20 weeks to get into a treatment facility, but after evaluation by probation, it does. So I'm arguing the new factors that Miss Shannon wasn't going to be able to complete the treatment that was medically recommended for in the time on the case that was anticipated as part of the 50 days to get into treatment.
Okay, so you said that she wouldn't be able to complete the treatment that was medically recommended for her in the time on the case, as what you said with regards to that 50 days to get into treatment. I guess, what do you exactly mean?
No, Your Honor, what I was saying is that she had 50 days to, you know, find and get into a treatment facility. According to the Department of Corrections letter, it would take, you know, 20 weeks, according to them, to get into the dual diagnosis facility that they recommend, so that, you know, the substance abuse and mental health needs of Ms. Shannon were considered seriously enough to not be ones to ensure that her rehabilitation incentive couldn't even realistically start within that 50 days. So yeah, so it's not that she couldn't have completed within the 50 days. It's that, you know, based on the analysis of probation, she wasn't even able to start it within the 50 days. And that's why I'm asking the court to, you know, still hold the stick of the remainder of her 4 months, which is 57 days according to my shorthand math, as an incentive for during probation on the other case to get into the treatment.
Isn't generally, after sentencing or rehabilitation needs generally not considered a new factor under case law?
Well, Your Honor, it was a factor in the sentence itself, and in general, I don't have the case in front of me, but I know they talk about, you know, a court can modify a sentence based upon frustration of purpose, and my argument is basically that because the needs weren't known, or needs were more extensive than previously known, that to maintain the sentence imposed at the time would frustrate the court's purpose in the sentence. And at least from the defense's perspective, I won't speak for the state, the defense's perspective, that the jail time was intended as a stick to promote the rehabilitation efforts of Ms. Shannon.
I understand that you said that it was a stick to try and promote her desire, I guess, to try and get into rehabilitation, but wasn't it an either or? That's how it was argued to the court. Either she get into a treatment facility and she has 50 days to do so because the court is limited on the amount of days it could stay reporting to jail, up to 60 days. So it was an either or. Either she get into a treatment facility prior to the amount of time permitted by statute, or if she can't do that, for whatever reason, there was no even argument of any stipulations as to that or any anything beyond that, either she get in within 50 days and then go into the treatment, or 4 months of jail.
Yes, sir. And I admit I did not express that part during sentencing, just because in most of the cases where I've had clients go to treatment, it usually doesn't take them, 2 months to get a bed. But this one, according to Agent Locker's letter, had they recommended more time than a greater sentence than I think was anticipated at the time, a greater rehabilitative need than was anticipated at the time.
All right, Mr. Marco.
Thank you. I think there's a couple of issues here that the court should consider. One, based on the motion's articulation of a new factor, my understanding of the new factor analysis is that it was unknown at the time of sentencing, or that it was overlooked, not that it was necessarily unforeseen. That it was a fact that either didn't exist or did exist and was not considered. I don't think that this qualifies under either one of those. As the court's already articulated, she had 50 days to get into treatment, or she was supposed to report to jail. It didn't say it was required for the Department of Corrections to put her there. I haven't seen any submissions that shown that she went and received an AODA assessment on her own and wasn't able to get in. There's no documentation of what her efforts were on her own to get in on her own capabilities. Simply relying on the Department of Corrections to provide that service, I don't think is realistic or what was expected at the time of sentencing. It was her obligation to get herself into treatment. If probation was able to facilitate that, then that's great. But it wasn't the Department of Corrections' responsibility to facilitate this for her so that she could exercise that privilege that she was given by the court to have that extra time to report in order to do that. So I don't think that qualifies as a new sentence or a new factor for the court to consider. Her efforts are independent of the Department of Corrections efforts. I also think the motion was untimely filed, as I believe the sentencing date was September 24th of 24, and the motion I believe was filed on December 25 of December 17, 25, which I think is just short of 90 days. So she didn't report at the time that she was supposed to report to begin with. Another consideration that I think needs to be taken into another factor that needs to be taken into consideration is looking at the last sentence of the letter from Agent Locker from the Department of Corrections, she also failed her urine analysis. So she was also consuming controlled substances that were illegal, that aren't prescribable and didn't have a prescription. Pulling it up here, it says for cocaine and THC. So
I also had a clean urine.
Nope. You should probably talk to your attorney. I can give you an opportunity to have a breakout session, but the state gets to finish his argument.
Okay.
So at this point in time, I don't see a legal reason for the court to grant the motion, as I don't think it qualifies for a new factor, and looking at all the facts and circumstances around it, I don't think that justice would support it either. I ask that the motion be denied.
All right, thank you. Mr. Keen, I am going to give you an opportunity to have a brief breakout session with Ms. Shannon before you make any reply, okay? Or rebuttal?
Yes, Your Honor.
Okay. All right, thank you. Okay, Mr. Keen, any reply?
Yes, Your Honor. Regarding the timeliness issue, I would note that the statute I put in the brief gives the court the authority to...
Your time is fine. You're within 90 days to be able to file.
Okay, all right, all right. And again, regarding the factor, like I said, Miss Shannon, she was worth probation, and she also has informed me, and if you need testimony, that she had made calls and stuff on her own, wasn't successful, and that she did do an AODA, if you want her to testify about.
I mean, that is fine. That's fine. You can have her testify. This is your case. It's not my case. It's my case to decide.
I understand that.
But I don't have time for her to testify right now.
Well, okay, well.
So if you would like her to testify, I am more than willing to keep this open and to give you another date and time for her to provide testimony, but I can't take it today. This was only scheduled for 15 minutes.
Frankly, I think if we push it out, it'll end up frustrating the purpose of the motion to begin with by the time we get back into court. So, okay. So, and then regarding the other issue, idea about factors, I agree it wasn't stated, but I said that at the sentence, did call for a secret, and the author Everett, she, looks like she was reporting to probation and trying to work with probation too, and to get assistance. And frankly, I think her overall cooperation with probation that during that period, because I mean, it doesn't say always successful. I concur, but I believe that holding that open and giving her a chance to work with probation to get in the treatment would better serve the interests of the public than an additional 57 days of confinement with no Huber or work release. And if that's not acceptable, I would ask the court to at least consider modifying it to allow her to get Huber.
Okay. All right. Well, based upon the information, the arguments that I've heard here today, I don't believe that there was an affidavit attached to the motion or anything by counsel or by client. And you definitely do need that in order to have your motion supported. And again, I didn't even get an affidavit from counsel or an attached affidavit from Ms. Shannon as it relates to the motion to modify the sentence. Timeline, time days, you are within the 90-day allotment under statute to be able to file a motion to have the court to consider a modification of the sentence. However, in a modification of a sentence motion and for a basis, the defendant must present a new factor for a sentence modification, and a new factor is something like a fact or a circumstance that is highly relevant to the judge who sentences at the original judge, but either it didn't exist or it was overlooked. And that's where the defendant can then ask for the court to look at this again to see how that factor truly did impact the original sentencing purpose. If we look at the arguments that are made here today, the fact that defendant is indicating that, but for unforeseen circumstances, the fact that her substance abuse disorder and or her mental health issues are more than anticipated at the time of sentencing, that is the argument for the new factor. But when the court looks at that and looks at the sentencing and the sentencing purpose, the sentencing agreement that was argued to the court, which was accepted by the court, included either Ms. Shannon enter into a treatment facility, an inpatient treatment facility within 50 days, or that she sit 4 months in jail. And that means 4 months in jail if she was unable to get into the facility, if she decided she did not want to get into the facility, she chose she didn't want to have any treatment. There were options there, and although it's argued that it's an unforeseen circumstances, the level and the extent of her mental health issues and or her substance abuse disorder, that should have been or could have been contemplated at the time of sentencing, and that could have been argued and negotiated with the state as part of the plea agreement and plea deal, or Ms. Shannon did not need to continue to with the sentencing and be sentenced on that date and time. She could have requested for additional time to be able to look into being admitted to a treatment facility, an inpatient treatment facility. Again, the sentencing purpose was either she get treatment or she sit the time in jail. No caveats were discussed, no caveats were placed on the record, and it should have been or could have easily been contemplated that something could have interrupted Ms. Shannon's or interfered with Ms. Shannon's ability to get into a treatment facility. So based upon that, the court does not find that there is a new factor or that something was not contemplated or it was overlooked at the time of sentencing. Therefore, the court is denying the motion to modify the sentence. As it relates to Huber and her request to have Huber release, Burnett County Court Jail does not have a Huber program. That would be something that would need to be argued to the court to allow her to have release on monitor, and that would be at her expense under house arrest. That is a completely separate written motion that would need to be filed and need to be heard by the court. I am not in a position, nor is Mr. Marco in a position to hear the arguments as to why she would like to be released on electronic monitor and what the basis is for that. So if that is something that she would like to be heard on, you can file a written motion to be heard, and the court can fit you in as soon as practically possible. And there are a lot of openings in the next couple of weeks. So the court is going to deny her motion at this time. All right, thank you. We are adjourned.
Can I just make one quick statement for clarification, please?
You may, Mr. Marco.
I apologize. I'll be as brief as possible. I apologize for my lack of clarity. My statement that the motion was untimely was not meant to be a jurisdictional argument for the 90 days. It was the fact that she had not reported within that 50 days. And if there was an unforeseen circumstances, the court had a 10-day buffer zone that it could have used to try and get to that 60 days. I just would have anticipated a motion within that 50 days to say we've had a problem and we'd like to readdress the issue. That was what I was referencing regarding timeliness, not 90-day jurisdictional argument. Thank you.
Thank you, Mr. Marco, and that's understandable. I understand your argument now, and the court does agree with that statement as well. There were 50 days within a motion could be filed for the court to consider any extension to the 60 days or for there to be any other discussion between the state and defense, and that was not accomplished. I can't recall how many days it was after, but I believe it was 70 or something days from her, from the date of sentencing until she came back for the status. So thank you for that clarification, Mr. Marco.
Thank you. Everyone have a great day.
You too. Thank you. All right, it's 11:01. Back on the record, same appearances as previously noted. It is 11:01. That is the time to start. So victims were notified for 11 o'clock. Victims' rights compliance.
Yes.
Excellent. Okay, let's call your first witness.
I call Austin Spafford.
Deputy Spafford, please come forward, raise your right hand, be sworn in, and have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
I do.
All right, you may begin.
Could you state your name for the record?
Deputy Austin Spafford.
How are you employed?
I've been a deputy sheriff for the Benita County Sheriff's Office.
How long have you been so employed?
3 years, 7 months.
So you were so employed on November 23rd of last year?
Yes.
Were you and some other deputies called out to the village of Siren for a call?
Yes.
Which other deputies went out with you?
Deputy Bailey Mangan and Deputy Gavin Antone.
Okay. What was the call for?
It was a call about a disturbance at an apartment building.
Okay. Did you go to that apartment building?
Yes.
Where was it?
In the village of Siren in Burnett County.
Just could you say it real quick at the end there? It's in Burnett County?
Yep.
Okay. What did you do once you got there?
Me, Deputy Mangan, and Deputy Antone entered the apartment building. We made contact with the listed victim in this case on a stairwell, as well as her friend. Deputy Antone brought the other male friend into the hallway and spoke with him. And me and Deputy Mangan spoke with the alleged victim on the stairway.
Okay. Did you confirm she's the one who called the disturbance?
Yep.
How did that conversation go?
The victim was initially kind of hesitant to speak with us. She wasn't very talkative. She was very emotional. While Deputy Mangan was talking to her, we were able to get semi kind of what happened. She said they were out, the defendant, her and that friend were out drinking at the bars in Grantsburg, Wisconsin. They decided it was time to go home due to the defendant's distance of where he lives. She offered to let him sleep at her apartment. They dropped the friend off at his vehicle in Webster, Wisconsin, got back to the apartment, and the way she put it, he began to become, quote, aggressive, punching the walls, stuff like that. When we asked, what else happened, she said he grabbed her by the hair and threw her to the floor, which caused her pain, that she did not consent. When we got that, we thought it was best to give her some time, as she was very emotional. We went inside the apartment to speak with the defendant. We found him located in the bedroom, passed out on the bed.
Okay. What did you do next?
We woke the defendant up, tried to speak with him. I observed he was heavily intoxicated, so much so that for the first 5 or so minutes we were talking to him, he couldn't formulate a sentence.
When you say I observed he was heavily intoxicated, what do you mean? What led you to that conclusion?
Slurred speech, glassy eyes, bloodshot eyes, the overwhelming odor of intoxicants just in the apartment building itself, or in the apartment itself. And then eventually, after Deputy Mangan was trying to communicate with that subject, we finally were able to get him to say that he was in his apartment, which we knew not to be true. We weren't getting anywhere trying to have a conversation with him. The decision was made to just place him under arrest for disorderly conduct at that point. Deputy Antone and Deputy Mangan escorted the defendant out of the building into a squad car. I then made contact with the alleged victim again in the stairway.
And how did that second contact with her go?
During my conversation with her, I did observe redness marks on the side, on each side of her neck. And in my training experience, I believe that's consistent with strangulation, choking of some sort. I asked her about it, and again, she was kind of hesitant to speak with me. But I asked about it again, and she said that the defendant had choked her. she said after he threw her to the floor, grabbed her by the hair and threw her to the floor, he got on top of her, put both hands around her neck and squeezed.
Did you ask her about whether or not this impaired any breathing?
Yes, she said. I asked her if she could breathe. She said she could not. I asked her if she lost consciousness. She was not sure, but she did state she could not breathe and that her vision did go blurry.
Did you observe any other physical symptoms indicative of strangulation?
Her eyes were dark red and bloodshot, yes.
What are those indicative of to you, and why are they indicative?
It's indicative of strangulation due to the amount of pressure when being strangled. The pressure buildup in the eyes can burst some blood vessels, causing the bloodshot eyes.
Your Honor, I'm going to object and move to strike. That seems like a medical conclusion without any foundation to have provided that conclusion.
I can rope around to that. Did you get any trainings in trying to find the symptoms of strangulation?
Yes, it's covered in the police academy, and as well as just trainings at the sheriff's office. We have a form that we go over with part of our domestic abuse paperwork that covers strangulation and shows those symptoms as signs of strangulation.
So your belief that these are signs of strangulation are based on your training experience at the academy, trainings you've gotten at the sheriff's office, and what's on the sheets?
Yes.
Okay.
All right, so that is, his objection is now sustained. Overruled.
Okay. So what did you do next after that second contact with her?
I advised Deputy Mangan and Deputy Antone that we had enough for a strangulation charge, which is a felony. Due to the defendant's level of intoxication, we were pretty sure the jail wouldn't accept him without medical clearance. Deputy Antone and Deputy Mangan transported the defendant to Burnett Medical Center.
Did you go with them?
I did not know.
Did they ever report to you afterwards how that went?
Like I said, I was not there, but they advised me he was very belligerent and uncooperative.
Okay. Did you see anything in the apartment to confirm what the victim was saying with the defendant going around hitting the walls?
Yes. When you enter the apartment, the best way to describe it is almost like a hallway. The wall to your right, if you're facing the apartment, runs all the way until it meets another wall. And then there's another shorter wall that then opens up to the kitchen dining room area. There were, I guess the best way to, it's almost like scratch marks where, like if somebody were to punch a wall, it would leave it left a mark on the wall in the paint. And that was up and down that entire right wall. I did ask her if those were there prior. She said they were not, and that she confirmed that was the area of the wall that the defendant was reportedly hitting.
Did you ask the victim if she could ascertain any reason why the defendant was acting in this way?
She had no idea. She said she's never seen him like this, and this was highly unusual to her. I did ask her if there was anything other than alcohol use, drugs, narcotics, anything like that, and she was not sure and said not that she knows of.
Okay. No other questions.
All right, Mr. Becker, questions?
Yes, thank you, Judge. Officer, you said that you were dispatched to a disturbance at the apartment, correct?
Yes.
Did dispatch relay to you the nature of the disturbance?
Just that the alleged victim had called, said the defendant was being, quote, aggressive, and that she wanted him removed.
So your understanding of the call was she only reported for the point of having him taken out of her apartment?
I have no idea why she called, but what was relayed to me is that he was being aggressive and that he needed to go.
She didn't at that time report anything physical in nature at all to dispatch, correct?
Not at that time, to my knowledge.
When you arrived with the two other deputies, you and Deputy Anton spoke with her for a period of time, correct?
Deputy Mangan and I.
Mangan, apologies. Anton spoke with the friend?
Yes.
Okay. And how long did it take you to get to the apartment after the call went out from dispatch?
We were north of Webster. We ran lights and sirens, so I estimating 10, 15 minutes at most. I would have to refer back to my report to know the exact time the call came in and time I arrived.
And while you didn't speak specifically with the friend, you're aware of the general conversation that was had with the friend?
I do not recall at this time exactly how that conversation went, but I was aware that he was not present for the actual disturbance. He arrived after.
Yeah. How did he arrive after? If you know.
In a vehicle. I would assume in a vehicle, but I guess I do not certain.
Apologies. That question wasn't that great. Why did he arrive? How did he come to arrive?
It's my understanding that the alleged victim had contacted him saying what was going on.
Do you know if that happened before or after she called 911?
I believe it was before.
The first time you spoke with, I believe her initials are NS. She only informed you about Mr. Belial hitting some walls and potentially pushing her to the ground, correct?
The way she said, grabbed her by the hair and threw her to the ground, but yes.
Okay. She didn't say anything at all about any incident involving her ability to breathe, correct?
Not at that time.
Okay. You and Deputy, is it Mangan? Did I say that right?
Mangan.
Mangan. Apologies. You and Deputy Mangan, how long was your conversation with her?
A few minutes. Like I said, she was very emotional and wasn't very talkative the first go around.
Did she seem somewhat reluctant to actually report anything to you?
I guess I don't know if it was reluctance or just she was crying pretty heavily, or just her inability to speak. I have no idea.
When you went into the apartment, you found Mr. Belial in the bedroom, is that right?
Yes.
How was he clothed?
Fully clothed. No shoes on, but fully clothed, I believe.
After you removed Mr. Belial from the apartment, you spoke with the victim, the alleged victim again?
Yep.
You said at that time you observed some redness on her neck, is that right?
Yes.
And you observed that her eyes were bloodshot?
Yes.
You testified earlier that Mr. Belial's eyes were bloodshot too, correct?
Yes.
And because his eyes were bloodshot, you believed him to be heavily intoxicated. In part, to be fair, there were other reasons why you thought that, but that was a predominant factor, correct?
Yes.
Was the alleged victim intoxicated as well?
I'm not certain. I know she had been drinking, but at the level of intoxication, I have no idea.
And so bloodshot eyes are a symptom, an indicator that law enforcement uses when assessing if someone is intoxicated, correct?
Yes.
So it's, and that's something that law enforcement relies on every single day as an indicator of impairment, correct?
Yes.
Did you have any other indicators of impairment related to the alleged victim?
The alleged victim, odor of intoxicants coming from her person. When it comes to slurred speech, I don't know. Like I said, she was crying.
In your experience, are people highly emotional when they get intoxicated?
Sometimes.
You said you pointed out the redness on her neck to her, correct?
I asked about it, yes.
And that at first she didn't want to talk about that at all or report anything to you, correct?
Yes, when I first brought it up, she didn't say anything, and then I asked again, and that's when she told me.
Okay. So it took basically until a fourth inquiry for her to report any form of a strangulation, suffocation type of incident?
I guess if you want to put it that way, yes.
You said that, or you testified that the alleged victim told you she had never seen Mr. Belial like this before, correct?
Yes.
Implicit in that is that they have a relationship of some kind, correct?
Sure, yeah.
Did she outline to you how long she's known him or in what capacity she's known him?
Not to my knowledge, no.
You don't know if she outlined that to any other officers on scene either?
Not to my knowledge, no.
Just that she'd never seen him like that before or known him to be like that?
Correct. And that they weren't in a domestic relationship.
Gotcha. And overall, the reason Mr. Belial was there is because she offered for him to stay at her apartment that evening, correct?
Yes.
And that they had met on a social occasion with, you know, some friends of friends or mutual friends or whatever it may be.
Yes.
Did she outline that it was kind of a planned meetup between everybody collectively?
That I do not recall. I don't know if it was planned to meet up or if they just ran into each other. I have no idea.
Okay. That's all I have. Thank you, Judge.
Thank you. Redirect?
No.
All right, then you may step down. Thank you, Deputy Spafford. Any further witnesses, Mr. Schmidt?
No, Your Honor.
All right. Mr. Becker, any witnesses?
No, thank you, Judge.
Do you want to make an argument here today, or are you satisfied based upon the testimony and knowing the burden that the court can make a decision?
You're right. I do understand the burden, that it is a probability, and what the court's decision is going to be based upon the testimony today. My only argument, and I haven't won this argument before, I will admit, is I believe implicitly when you have to deem something as probable, there is a level of credibility that must come with that. And I think the testimony today kind of underscores this, the defense's position as to the credibility of the report made in the way that it was made. But I 100% understand the burden for today and what the court's decision will be. Thank you.
All right, thank you. Mr. Schmidt, do you have any comment off of his brief argument?
Just I think the case law is pretty clear that the court can't weigh credibility at these. What the court can weigh is what's called plausibility. So it needs to determine if what was said is plausible. Thank you.
All right, thank you. And plausibility here, the court has to determine whether or not a felony was probably committed by the defendant, and the court must hear all testimony and view all evidence in the light most favorable to the state. And it is for a jury to decide and to determine credibility of any statements made or any differing arguments, or whether or not there is truthfulness in these statements and or arguments. So based upon that, the court will find that the state has met its burden that a felony was probably committed by defendant in Burnett County. I do find that probable cause, and I will bind the matter over. Information, Mr. Schmidt.
I filed the information. It mirrors the criminal complaint.
Proceed with the arraignment here today, or set it for another date, Mr. Becker.
Your Honor, I am fine to proceed today. I talked about this with Mr. Belial. It doesn't look like the information has come through, but with the state's assurance that it mirrors the complaint, we are fine to move forward with not guilty pleas on all counts, waiving speedy trial at this point.
All right, thank you. The court will enter not guilty pleas on Mr. Belial's behalf. He is entitled to a jury trial, would be entitled to a speedy trial. Right now, he is waiving the speedy trial demand. Let's set this matter for a status conference, giving both sides an opportunity to have time to negotiate the matter and for Mr. Becker to review the discovery. I can do February 27th at 9:30, February 27th at 9:30, if that works. Video, Zoom is fine for both.
Your Honor, that does work for both of us.
All right, February 27th, 9:30, we will see you here. And again, video conferencing is permitted. Anything further?
Not from the state.
No, thank you, Judge. Have a good day, everyone.
All right, thank you. We will go on the record in the matter 13 CM 280, State of Wisconsin versus Benita Pinalosa. We're set here today in this matter for a sentencing hearing after revocation. All parties in some way or form are appearing by video conferencing, except that James McLaughlin and his client, who is in custody, are appearing in the Washburn County Court. District Attorney Aaron Marco is appearing by video conferencing, as is this court, who is appearing from the Burnett County Courthouse. Again, set for a hearing after revocation. The court has reviewed the revocation packet and all matters as it relates to the previous sentencing in this case. Mr. McLaughlin, is your client okay with everybody appearing by video conferencing and not in the same room?
Yes, Your Honor. Her name now is legally Spencer, S-P-E-N-S-E-R, correct, Ms. Spencer?
C-E-R.
Oh, C-E-R, I apologize, S-P-N-C-E-R. And you are agreeable to this proceeding being handled in the technological manner recited by the court, correct?
Yes.
Thank you.
All right, thank you. And I apologize, I don't have that information that it is Spencer, or if I did in the revocation packet, I'm sorry, I would have kind of overlooked that because I have your name as legally Pinalosa, okay?
That's okay.
So I apologize. Oh, I did see it. I guess I see it in parentheses. Okay, so anyone notice anything, any material information that needs to be corrected on the record, Mr. Marco?
Not from the state, no.
And Mr. McLaughlin?
Your Honor, I have reviewed the sentencing after revocation packet verbatim with Ms. Spencer, and we see no additions or corrections, correct, ma'am?
Exactly.
Nothing in dispute, Your Honor.
Thank you. And Mr. Marco, to the best of the state's ability, are we in victims' rights compliance?
I believe that we are.
All right. Okay. Thank you. Argument, Mr. Marco?
I believe that we have a joint recommendation for 4 months in the county jail. The Department of Corrections recommends 3 to 5 months, and looking at her criminal history before this, she only had one prior conviction for retail theft. My understanding is that there was a $62 check that was passed without sufficient funds. Following that, she basically absconded for probation from over a decade. She returned, was caught, and Attorney McLaughlin sent me an email. I believe she has approximately 72 days of credit. I think that is sufficient in this instance, and I would ask that all financial obligations that remain be reduced to civil judgment.
All right. Thank you. Mr. McLaughlin?
Everything is accurate about what Mr. Marco said, Your Honor, except she has 97 days credit from October 10, 2025 to today's date of January 16, 2026 is 97 days, Mr. Marco. Would we agree on that?
Yes, we can agree on that. I apologize for misspeaking. I was working off memory. I didn't have your email in front of me.
All right. May I just briefly address the court, Your Honor?
You may.
Your Honor, we have agreed stipulation. The 3 to 5 is consistent with the Department of Community Corrections recommendation. This is a 2013 case. Ms. Spencer Penizola was convicted in 2014. She married and she did abscond to Indiana. She later returned to Illinois, and she was arrested in Kenosha in last year. There was an incident in Kenosha, allegation 3 contained within the sentencing after revocation packet, which was reduced to an ordinance. She represents that since the date of this conviction, she has had no criminal convictions or since. Therefore, she regrets that she did not comply with probation. She has served 97 days. As a result of this, she is age 54. She represents she does not drink or do drugs. Again, she's had no criminal convictions since that time, over a decade. Therefore, I believe that she has been reasonably and fairly punished as a result of this incident. We do not object if there are any financial or otherwise obligations owing as a result of this probationary period, that those obligations be reduced to a civil judgment against her. So therefore, Your Honor, in terms of the triad of factors under McCleary v. State, Wisconsin seminal sentencing law, I believe the needs to protect the community, to hold the defendant accountable for her failures, and potential rehabilitative needs have been met. Her plans in the future going forward are to return to the state of Illinois, to live by or with her sister, and to apply to and to address the financial obligations that she may have. She intends to specifically to apply to the Kenosha Amazon store, which to her understanding is hiring. Thank you.
All right, thank you. Before I ask Ms. Spencer if you have any statements you want the court to be aware of, I have a very old address. Can I get an updated address for you, please?
Yes.
All right, can I get an updated telephone number, please? Thank you. And before I go into the sentencing, I am letting you know and Ms. McLaughlin know that before you are released from custody, after that takes place, you are ordered to provide your social security number to the clerk's office, okay?
Okay, not a problem.
All right. Okay, Ms. Spencer, anything you want me to know or be aware of?
Yes. Well, my lawyer pretty much covered everything, but any financial obligations I will take care of in a very timely manner.
I appreciate that. This is a very old case, extremely old, and quite honestly, I do not understand the sentence that occurred at the time of placing you on probation and with a withheld sentence. Quite honestly, it's archaic. And the fact that we have issues of worthless checks, the number one goal here is to make the victims whole. And that is to ensure that, you pay back the worthless check money and any costs associated with that. Unfortunately, it got to where it is today and where it was at the time of sentencing. And so now it looks like you owe a total of $1,199.96. And that does accumulate interest, I believe daily or quarterly or however it's calculated. So it's very important that you look at this and you try and get it paid off. Honestly, if I'm looking at this, restitution, you still owe $899.82. For the most part, these are all surcharges. I'm looking at court costs of $176. I'd be willing, if you're willing to get this paid off in a very timely manner, I'd be willing to knock off what I can, and the only thing I can knock off is that $176 in court costs and fees. So you're hoping to get a job and you're hoping to get this paid off quickly, which that's what I look at, and that's the main thing. You've already been punished now. Again, for cases like this, you rarely see jail time unless this is something that is in the person's pattern and their conduct, that they do this and that they do this a lot. So you've been punished now, sitting the 97 days that you've sat in custody. Do you have an idea of when you'd be able to get, and it's going to be approximately a little over $1,000 if I knock off what I can. Do you have an idea of when you can get that paid off?
Be realistic, man.
I'm thinking, would I be able to make payments on it, or would I have to?
Yes,
okay.
I'm fine with that. I'm just trying to figure that out because I want to give you that incentive. Again, I'm sorry in that I can only waive $176, but that's all I'm legally able to do. But my goal is to get this paid off, not only for the victims, but for you, because quite honestly, I will issue a warrant. You'll be in Illinois, and that could affect your life.
I understand that completely.
Could you do it in 6 months?
Yes. Making
Okay,
payment
let
like
me,
I've done in 6 months.
okay, so 1,000 roughly. So that would be, let's say, at minimum, let's just do $200 a month payment, and you pay that to the clerk's office, to the Washburn County Clerk's Office. They have an ability to give you information on how to be able to pay it online. But so 6 months, so that's January, February, March, April, May, June, July. Let's say if you have it paid off, excuse me?
I'm sorry, can we start in February, not January?
Yes, that's fine. So that would be August. So if you have it, the little over $1,000 paid off by September, the end of September, I will waive that 176, that other 176, okay? So when you are released from custody, once you are released, go to the clerk's office, give them your social security number, and have them give you a sheet of all that you owe, so you have an idea, because then you can, when you look at it and you see the court costs, you can deduct that $176 and know that you're not going to have to pay that. You have to pay the other amount. But once you have your amount paid, that total amount paid that you will owe, write me a letter and say, Judge, I've paid it off. Can you please waive what you can?
Okay.
All right?
Ma'am.
I believe that the agreement is appropriate. You've already been punished, and there is a plan now to get all that is owed to the victims, and with regards to the courts, with the surcharges and things to be paid off. So this is appropriate. I'm going to sentence you to 4 months of jail, 97 days of jail credit. That is a time served, and you do stipulate to that, Mr. Marco? All right, he indicated yes. Okay, so he stipulates to that. And so that means a time served. Again, this has accomplished the public interest, as well as the punishment factors. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is entering a civil judgment for the amounts that you owe. You will pay the Washburn County Clerk's Office and do all that I've instructed you to do. If you fail to make a monthly payment, or you fail to pay this off, the court will issue a warrant. You could sit up to 6 months in jail. It's very important that you make sure you pay that off. I believe they have your DNA, but if they don't, I'm ordering you to provide your DNA to the jail. You would have the ability to request it be expunged from the CODIS system through a written letter to the Department of Justice, not to me, to the Department of Justice. I believe that covers everything, Mr. Marco.
I believe so as well. Thank you.
Mr. McLaughlin.
Your Honor, Ms. Spencer's indicated she does not object to the court's ruling, but you have covered her appellate rights. All I would add is that she understands that the services of her attorney continue in that 20-day time period. Thank you.
All right, thank you. And she understands, she nodded her head. Thank you very much. We are adjourned.
Good day, Your Honor.
Thank you.
Good day.
This is Ada Molina, Austin Cruz versus Diaris Nellums, Peachtree Truck Leasing versus ProMed Imaging and Unified Medical. But essentially the case took a turn because at the last meeting, the attorney for Caston Cruz, the plaintiff, Mr. Tristan Gillespie, presented a document to the court that had, I guess, was created by an AI application, an artificial intelligence application, and there were cases cited to and presented to the court as legal authority that did not exist. And so the court made a record, assisted by the Mr. Kennedy, who's the attorney for the defendant, who had gone through and basically noted all of the instances where there were documents, where there were cases cited in the document, but they did not, were not actually cases under Georgia law to which the court could lean for legal authority. All right, so at that point, I informed Mr. Gillespie that I would be sending this information to the state bar, which I did. And I have not heard back from them other than that they have received the information and it is in process with the general counsel for the state bar. But I did tell Mr. Kennedy and Mr. Gillespie that we would reconvene to determine what sanctions, if any, the court would impose. All right, and so I have Ms. Middleton. Yes, ma'am.
Good afternoon, Your Honor. I represent Plaintiff Cruz. We filed an entry of appearance on December 31st. I left counsel a voicemail this morning, and we do have plans to connect after this hearing.
All right. So, Mr. Kennedy, I did ask you for your suggestions for the any sanctions that the court might issue in this case. But I think I need to hear from Mr. Gillespie first, because Mr. Gillespie, I gave you an opportunity to respond. And essentially, from what I understand, the basis of your response is that you relied upon the app to assure you that it was correct?
That's right, Judge. I'll confess the technology is new to me, and thanks to this case and the motion and Your Honor, certainly much more educated about the pitfalls and dangers and so forth. And clearly, it's not sufficient to rely on large language models to verify or validate case citations, and so much so that we went through the effort and expense of getting proper legal research software, which of course I use solely now, rely on heavily. I think at this point, before we get into a discussion about any possible sanctions, I think it probably would make a certain amount of sense to wait to see what the Georgia Bar thinks of my response. I think it would be premature to impose any sanctions until we saw if they saw any validity to the defense that I raised and that I just explained.
Okay, Mr. Gillespie, apart from what the bar might opine as to the response that you gave, you filed a pleading with the court that was replete with cases that did not exist and were not, in fact, legal authority. And as a member of the bar, you're responsible for whatever you file with the court. And if you file information that is incorrect, erroneous, untrue, then you're responsible for those filings. You have delayed the course of this case because I could not even undertake the matter, the primary matter that involved the plaintiffs and defendants in this case. I had to spend court time addressing the fact that you sent in a brief that was essentially fiction. And so based on that, what the bar decides to do with respect to your violation of the legal canons and rules that govern members of the bar is separate and apart from your wasting court's time, you're diverting the court's attention from the primary issues in this case, and taking away from the plaintiffs and the defendants' opportunity to be heard. You've elongated this case in a way that wasn't necessary because now the court does not have faith in your ability to represent the plaintiff in this case. I'm appreciative that Ms. Middleton has come into the case to represent Ms. Cruz because I would not feel comfortable going forward with you as the attorney solely representing Ms. Caston Cruz based on your performance here before the court. So, Mr. Kennedy, did you have a suggestion for what you wish to have happen in this case?
Yes, Your Honor, and I did file the motion for sanctions, which you encouraged me to file after our last hearing. And I would just point out, I mean, it's not just like this was one brief, this was several briefs that were filed before the court that contain these same problems. And I think bare minimum under OCGA 915-14, I would ask for my client's reimbursement of all of our fees.
Playing from Tristan's iPhone.
All right, don't know what that was.
Ahead, sir.
Yep. All of our fees up to this point, because like you said, basically all we've done at this point is deal with these issues. We haven't even gotten to the substance of the case, and it's already been, we're getting close to a year since the complaint was filed. And it's just been a waste of time and an expansion of the case to this point. But I would also ask you to just dismiss this case, Your Honor. I think as you pointed out in our last hearing, the content or the conduct has been direct contumacious conduct to the court. It's a written document submitted to the court as legal authority in support of legal arguments which have no basis in Georgia law and are just fictitious. And, we can't live in a system where this is how we operate, and it's just not how the process is supposed to work. We can get into the way this case has gone down too, but we've had issues with getting discovery responses. We've got a summary judgment motion pending right now based on failure to respond to discovery. It's not just only the AI and use of AI, which I'll also point out, you gave him a chance to tell you this last time, and he said nothing. We called it out and we asked him what was going on, and the response was, you want me to provide additional briefing? Or just, oh goodness, not sure how that happened. And now we find out he knows exactly how it happened, and he knew then how it happened, and he didn't tell us. And that's just a violation of the lawyer's basic duty of candor to the tribunal, Your Honor. And I don't think that bringing in another lawyer necessarily absolved all the prior behavior and, sins of counsel, so to speak. And you can just now wash it all away and move on because we've got another lawyer involved. My clients have been prejudiced by this. We've got significant questions about this case anyways, outside of all these issues, which I'm happy to get into further. But I would ask this case be dismissed and my clients be reimbursed for their fees and expenses up to this point. And I provided you an affidavit as to that number back in August when I filed the motion. It's part of my motion for sanctions, where I also outlined all the instances of the cases that have been either are just totally fictitious or were cited for like a completely different proposition than what they were, than what the cases actually say. And so that's exhibit D to that motion. It's my affidavit of fees.
All right.
If I may add, Your Honor, we don't disagree with the procedural history of this case, but we would like to object to counsel's dismissal.
Wouldn't be my dismissal, it'd be the court's dismissal, but.
Well, your suggestion of the dismissal.
Okay.
All right. Well, you say you're objecting, you got to give me some basis for your objection.
Yes, Your Honor. So the plaintiff here has terminated previous counsel. It's my understanding previous counsel has also been terminated from the firm as well. My basis on the objection would be that plaintiff had, no idea this was going on, and as such, shouldn't be prejudiced because of this. My goal would be to get this case back on track. It's my understanding there was a consent motion to discovery filed with discovery expiring, I believe, the first week in March. So we would want to be as diligent as possible and still maintaining that deadline and getting the case back on track.
I want to be mindful that the parties in this case are not the primary drivers when it comes to filing motions and attending to court processes. And so if I'm going to sanction in any case, someone who's acting on behalf of the parties, if Ms. Caston Cruz is unaware that her attorney is filing fiction, it would be unnecessarily punitive to her. I get that the case has not moved in a manner that is expected. But civil cases tend to have issues with timing anyway. Civil cases can, there's no real expectation of how long a civil case is going to take. We hope for things to be done in a timely manner. We have a structure for how discovery should be conducted. We have a structure for how cases should proceed, but mere timeliness is not something that we can really, that's really a factor that we can guess about or know about from the outset. What I do have is a desire to make Mr. Kennedy's clients whole, in as much as he's had to respond to these motions, he's had to spend court time, he's had to spend office time, he's had to address all of these filings, and then the volume of the filings, when really to tell me to file a huge filing just to tell me that you relied on ChatGPT to tell you that ChatGPT was right. We had a training for judges about the use of AI, and essentially the main thing that was beaten into our heads was you are responsible for everything that is produced, whether you use an artificial intelligence application or not. There are ways to use it to effectively manage the workload of cases and documents and having to read tons of filings, but you can't rely upon, especially something that is open source material at this point, like ChatGPT is open to anybody, and it is not an application specifically for use as a legal artificial intelligence engine. It is software for people. One of my friends uses it as, she says, like, it's like her wife. She'll say, hey, make a grocery list. Hey, write this letter for me. Hey, set up a schedule for my children. And so it is assistive in that way, but you are responsible still, because I'm so old school that this is the phrase that keeps coming to my head: garbage in, garbage out, which we were all told when at the outset of, and I'm old enough to go back to when we switched from typewriters to personal computers and to software, to the software for personal computers that allowed us to type and produce documents. And so at this point, I'm not inclined to dismiss the case, because I really feel like Ms. Caston Cruz has no clue about the breadth of issues that have popped up that have nothing to do with the merits of this case. However, Mr. Gillespie, I'm not inclined to just wait until the bar resolves it, because that has nothing to do with the fact that you have caused an inexcusable delay, that you have not been candid with the court, that you have not done what is necessary for all attorneys to do, which is to manage your work product and make sure that you are producing products before the court, and giving case law and statutes upon which the court can rely. And so with that being said, the court is inclined to grant the sanctions asked for by the defendant, Mr. Kennedy, and to make those sanctions personally payable by you. They are not to be borne by the party in this case, Ms. Caston Cruz, or the firm. Those are sanctions that you should bear yourself, because it was you who made the decision to rely upon an open source AI application to file legal documents, and to not go back through those legal documents to ensure that the case law that you presented was reliable, was true, was not erroneous, was in fact actual case law that a court could rely upon. And I saw it, but I can't find it now. What is the amount that you're seeking, Mr. Kennedy?
So as of August, when I filed this, it was $25,498.08. That's fees and costs.
All right. So, Mr. Gillespie, there will be a judgment against you personally, a sanction against you personally for the amount of $25,498.08 to be paid to Mr. Kennedy. Is that to be paid to your firm?
Yes, ma'am. And then we'll get it back to the insurance company who's paid it.
And Judge, just so I'm clear, that's the entirety of his fees from the beginning of the case till today?
Mr. Kennedy?
That's correct.
I'm not hearing you invite a response to that, but that seems excessive. I understand that that your opinion that I have caused undue time and expense expended by him, but what I have not heard you say is that 100% of all of his time and thus that fee is attributable solely to my alleged transgressions.
Mr. Kennedy?
I didn't go through and itemize. Like I said, this is just for the whole case. The way I've kind of viewed it is this is all we've been doing in this case so far is basically, him filing, me responding to these types of briefs. But Judge, if you want me to go through and itemize it further, I can do that.
I'm not inclined to do that, and this is why. One brief I could understand, but if this is the tenor of the type of practice that Mr. Gillespie has engaged in this court, and in this case, so I'm not going to nitpick at this point. I feel like from the outset of the case, if you're not practicing law the way you're supposed to practice law, if you are not making sure that you are attentive to the reliability of what you file, the truthfulness of what you file, if you are filing things with no regard to to what your client is entitled to the representation that your client is entitled to, then I do not believe that is an excessive amount. So $25,498.08, that's to be paid to Mr. Kennedy's firm. That is not to be borne by anyone but Mr. Gillespie.
Judge, is there a timeline you want to put on that?
120 days.
And would you like a proposed order, or will you have one?
Please submit one.
Okay. Your Honor, if I may, I know you've indicated you're not inclined to, dismiss the case on a sanctions ground. Are you planning on taking up the summary judgment motion today too?
Ms. Middleton, you're just coming into the case. Can we get back on track with the merits of the case?
I believe so, Your Honor. In all honesty, I have not had a chance to really take a look at that motion for summary judgment. I did see some mentions of reopening default in the docket. If counsel's willing to get this back on track with discovery, we would have no reason to oppose that. And I'm happy to get on a call with counsel once this hearing wraps as well.
Here's my only issue, Judge. So I filed this motion for summary judgment because they didn't respond to requests for admission, right? So under OCGA 1136, those are just deemed admitted. And the case law is very clear that to overcome those deemed admissions, they've got to provide credible, admissible evidence that would refute them. And there is none right now. They filed a reply brief that had an affidavit from their client that is inaccurate, and we can go through it if you want. I can show you exactly why.
She's got, first of all, a different date of a motor vehicle collision, saying I was involved in a motor vehicle collision on January 4th, 2024 on I-20 in Douglas County, Georgia. And can I share my screen on here?
Your Honor, if I could be excused, I know a lot of this going forward doesn't pertain to me.
Yes, Mr. Gillespie, you may be excused. We'll get you in order.
Can you see my screen, Your Honor?
Yes, sir.
Okay, this is the police report from our case. As you can see, I can try to.
I have December 14th, 2023.
Right. In Gwinnett County, totally different day than in her affidavit, sworn affidavit that has been submitted to this court, which again is just kind of consistent with how things have gone, says that this is the day that she got in a motor vehicle accident and was injured. I mean, it's I don't know what to do at this point. That's all the only evidence they have, apparently evidence in quotes, is this affidavit from plaintiff that says she was injured in a motor vehicle collision on a completely different day that she supposedly received medical treatment for. But then again, we've got these requests to admit that they're deemed admitted that basically say, my medical treatment wasn't caused by this accident and wasn't necessary, and those sorts of things that just completely defeat her case. So at this point, I'm not sure there's a lot to even argue on their side as to how they overcome a summary judgment motion. So that's why I was asking I know you're not inclined to dismiss it on just a pure sanctions ground under 915-14 or because of the contumacious conduct to the court. But I think I'm also entitled to you granting summary judgment in my favor.
All right, Ms. Middleton.
I mean, the fact that there's a police report showing that the wreck happened, I mean, obviously there's some meat there. I mean, we would obviously object and request for an additional 30 days to respond to the motion for summary judgment, if you would be inclined, Your Honor.
Well, kind of not, because at the point where I guess you came into the case, we had been dealing with the sanction issue, and that has been more than 30 days. So from that point, Mr. Gillespie and the firm and whoever he's dealing with had noticed that there was a pending motion that the court did not hear, and that there was time at that point to address that pending motion or to come up to speed on what that was. And at this point, the court's not inclined to continue to delay this issue. To Mr. Kennedy's point, if the discovery is deemed admitted and we're dealing with the basis of, okay, these facts are a part of the record, then you have to come with the strongest evidence to show that the deemed admitted facts have that there is something to counter those facts that have been admitted by failure to respond to discovery. So just the fact that there are two police reports or two incidents of an accident, one in January of 2024 and one in December of 2023, the existence of those divergent things is one thing, but none of that is enough to overcome what has been admitted.
I'll also just point out that she also in the affidavit says that she was struck from the rear by a vehicle. And I can pull back up, but the police report from our case, she was backed into. So it's like a completely different mechanism of the way the accident happened too.
And given the procedural history of this case, Your Honor, I do think we have good cause to possibly withdraw or amend those omissions. I would want to move to do that.
Well, that's already been done.
This is the issue that I'm having, though. Y'all have, I don't know how you got into the case, Ms. Middleton, and so I don't want to beat up on you too bad. But the issue is that y'all have had plenty of time, because since we had the first sanctions case, I know that was probably sometime in early October, or I feel like it was October.
August.
It was August, because I've gone to judicial training since then. I've come back. We've had the holidays. So since August, we've had a substantial amount of time for you to file whatever you wanted to file. Because had I decided to accept your filings, fine. They're already on the record. Let's deal with them. But I didn't restrict anybody from filing anything. The only thing I asked for at the point that we left in August was for information about the filings that involved Mr. Gillespie and the sanctions. I don't know when you came into the case, but there was plenty of time entering the case to file whatever was necessary to protect the rights of Ms. Caston Cruz. And so if you didn't make use of that time, there's not a lot I can do in this case.
Well, and Judge, I mean, they did file a response to my motion for summary judgment, and they did file a motion to amend or withdraw their deemed admissions. It's not like nothing's been briefed and been filed. I mean, this stuff was all briefed and is in front of you and was briefed back in September and August and October.
The issue is, though, that I don't have a lot of information that says we need to overturn the admissions and reopen that part of the case. And also, I'm kind of leery of what was filed because it was filed by Mr. Gillespie. At this point, the court has no confidence in the validity, viability, or legal basis of anything that Mr. Gillespie files with this court.
So am I taking that as you're disregarding basically his response briefs and the pleadings, the briefs he's filed? And at this point,
unless I'm hearing an argument from Ms. Middleton.
Again, Your Honor, we do not disagree with the procedural history of this case. We started the case on November 26th. We have been having difficulties getting the file. So, I do apologize if my knowledge of the case isn't exactly in alignment with the procedural history of the case. So I do want to be honest about that. But, again, we would want to move to withdraw and amend the admissions, based on the previous procedural history of this matter.
So when you came into the case, you came in relying on what Mr. Gillespie filed, and you didn't file your own or amend?
We did rely on the Felicetti firm, which was the firm that Mr. Gillespie worked for. I knew that he relied on ChatGPT for the filings, and I knew that was an issue. But in terms of the admissions, I really wasn't aware of that.
The issue is, and I know you know this, Judge, so this isn't going to educate you, but the problem is for them to be able to withdraw and amend their admissions, they have to show that the admitted under Inter-South Properties versus Contractor Exchange, which is 199 Georgia App 726, the admitted request either can be refuted by admissible evidence having a modicum of credibility or is incredible on its face. And at this point, there is no evidence in front of you at all to refute the admissions. I mean, that's the problem.
No affidavits, no certified copies, no
medical record
filed with
There's just nothing. So there's one 5-paragraph affidavit that we've already shown is not even reliable. So I'm sympathetic with Miss Middleton. She's only been in the case for a couple of months, but at the same time, you don't always inherit the best cases, I guess. It's just how it goes sometimes.
Well, and this is what I say. Knowing the procedural history of the case, at that point, if I'm coming into a case that is problematic, I would amend the filings. I would ask for leave of court if necessary, but I would definitely amend the filings that were already done to preserve the issue, but to amend them to perfect them such that by the time that we actually argued the case, then the amended filings would take care of whatever deficits were done before. There's nothing that prevents you from amending a pleading. There's nothing that prevents you from, if your response was done by the previous attorney, coming in and amending and updating that response or providing additional evidence that would support and give the court a basis for the decision to overturn the fact that the admissions had been deemed admitted.
Or bringing evidence or witnesses to this hearing. There's a lot of ways to do it. But Your Honor, I think you could issue an order in such a way that it wouldn't extinguish any claim that the plaintiff may have. Not against my clients, but if that's of concern.
Is this a first filing? This is not a refile?
To my knowledge, it's not a refile.
My knowledge as well, Your Honor.
Although, if I'm not mistaken, maybe I'm getting my cases mixed up. I think the complaint says it's a refile, but I was never aware of a first filing. I'm gonna look right now.
All right. Okay, so the court is going to make a decision in this case. And I will issue an order. Mr. Kennedy, if you will get me an order on the sanctions, I'll go ahead and sign that.
Okay.
All right, Ms. Middleton, the cases are what we get. I was in civil practice too, so I understand that sometimes if you take over from another attorney, it kind of is what it is. But let me have some time to consider all of the. I'm not a superior court judge, so I can't balance the equities, as it were. But I do have to consider, fairness and balance those things that would affect each of the parties in this case. So, all right. Thank you, Mr. Kennedy. Thank you, Ms. Middleton. And we will get an order out to you.
Thank you, Your Honor. The only, before we go, if we could, and this may be something that I can work out with Ms. Middleton, I don't know, but we do have the motion to open the default as to liability and set aside the liability judgment as to Peachtree Truck Leasing Company.
Peachtree Truck Leasing, right.
Right, which we were going to take up in August, and then we never got to it.
Yeah. So what we had talked about was the default was in, and then we were talking about whether damages hearing would prejudice the remaining parties in the case because of the information that had to be presented during the damages hearing. And so that's sort of where we left it before all of the issues with the briefs.
Right. And so you already ruled that we couldn't have a damages hearing because there was still one defendant that wasn't in default. This is a slightly different issue because I'm asking you to open the default and set aside the judgment as to liability as to Peachtree Truck Leasing altogether because they're an improper party in the first place. And I told Mr. Gillespie, but I'll tell Ms. Middleton now. I know who the proper party is. I've put it on all the briefs. And all I'm asking is that we just swap out the parties so we get the right entity in here. I'm not trying to hide the ball or extinguish any claims or anything. We're just trying to get the proper parties in. And Mr. Gillespie was, I guess, holding on to his default judgment that he'd gotten as to this Peachtree Truck Leasing, which again is not a proper party. And we didn't want to agree to lose that. I don't think the plaintiff is prejudiced at all by getting the correct defendant in here and litigating on the merits since we already have Mr. Nellums not been in default at any point. But that's the issue there. And again, maybe Ms. Middleton.
Okay, let me ask this. Do you also represent the proper entity?
I do, yes. So there won't be any issue with that.
All right.
Yeah.
Yeah, we would not want to keep the wrong entity in, so we'd have no objection to that.
Okay. I can put that in a proposed order too then if you want.
Yeah, please do.
All right. I think that was the only other only other thing on the table.
All righty. Thank you all.
Thank you.
Thank you. Thank you, Your Honor.
And that's how the cookie crumbles, ladies and gentlemen. You know, AI has its uses. It has its not so great uses. One of those things is creating documents where you're asking it to, hey, find me this thing that tells me that I'm right about this thing. AI will absolutely go out there and just make that thing up to be like, hey man, you're right if you say this. If you say this thing right here, you'll be right. The problem is in law, you have to be able to cross-reference those cases, and they have to be able to be real. And if you present those cases to a court as if they are real, then, you know, you're responsible for what happens. If somebody actually researches that and says, hey man, I don't think this exists. Got one lawyer that's learning a hard lesson tonight because of that very situation. And a hefty fine to go along with it. Ladies and gentlemen, I am your Lone Wolf Usul. I am your host for these here videos, and thank you very much for choosing to spend your time with me this evening. And chat has been amazing. I do thank you all very much. KFAR, thank you very much for coming by and dropping off some of your viewers with us tonight. And I do want to say a special thank you to Kirnoth for your contribution with the super chat. That's so awesome. Thank you so very much. Ladies and gentlemen, I'm your Lone Wolf Usul. I've done my thing for the evening, and I'll be back same wolf time, same wolf channel tomorrow. Ladies and gentlemen, I'll see you then, and don't get in trouble, because if you do, we might find you in a court, and we'll be seeing you then. I'll see you next time. I'm out. Fool some of the people some of the time, but you can't fool all the people all the time. Somebody says that if we all work together, we can all convince ChatGPT that Rhonda was the 47th president. I don't think Rhonda would even want us to do something like that. But hey, this is our Ferris Bueller reference for the day. Have a good night.